All right, the court is calling 2024 CR 012208, State versus Keontae Smith. Can I have parties announced?
In the crane behalf of Mr. Smith is to my right.
And we are live in Judge Boyd's courtroom. We've got a full docket today, and we are starting hot with a deferred adjudication plea. For those of you new here, deferred adjudication is basically the court saying, we're not going to convict you yet, but you have to be on your absolute best behavior or else. And the or else here, up to 10 years in prison and a $10,000 fine. So let's see if Mr. Smith understands the massive gamble he is taking today. Drop a comment if you think deferred adjudication is a second chance or a trap.
All right, and are you Mr. Smith?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Sir, you need to have a seat. All right, Mr. Smith, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
And up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yeah.
Do you believe he's currently competent and was legally sane at the time of the offense?
Very much so.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, punishment is to be assessed at a cap of 5 years. The state is silent on your application. There's a $1,500 fine. There's to be registration, no contact with the complainant, TAP evaluation, Mick Myoff evaluation. And counsel, the court is aware that ADA Unkefer was a part of the plea bargain agreement and that there were some issues with competency.
We did have him evaluated.
Wait, rewind that. The judge just mentioned there were competency issues and that the defendant gets a check from the government for a mental disability. This is a massive red flag in the legal world. We just heard the judge say he was evaluated and came back clear, but now we're hearing about SSI and cognitive limitations. This is the part of the video where you need to pay close attention. If a defendant doesn't fully understand the charges, a plea might not hold up on appeal. Is Judge Boyd about to let this slide, or is she going to dig deeper?
He came back clear, but just for the record, he does get a check from the government for mental disability.
Okay. All right. So, Mr. Smith, did you understand that as your plea?
Yes, ma'am.
State defense, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
The government states one at a time.
No, no objection.
All right, state you may be excused. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports?
Yes, Your Honor.
But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. We're proceeding with sentencing.
Yes, please.
Anything you wish to say on behalf of your client?
Just Your Honor, his mother has been very involved in this process. He's got a lot of support back home. He does have a mental, intellectual disability. He does receive, I believe, an SSI. As a result of that, there were some concerns about that going in. I think we got him again cleared by the competency evaluation, but that report very well outlined his history of just limited, I think, cognitive understanding on some things, and also just, I think you're on a few medications as well.
Sure.
And so we'd ask the court to take that in consideration. I think he's a good candidate for deferred adjudication. He doesn't have a criminal record. We'd ask the court to give an opportunity.
All right. And I see in the stipulations that he was given his Amazon account information for somebody to use.
Yeah.
Hold up. Did she just say Amazon account information? Let's break this down. The defendant gave someone his Amazon login. That might be tied to the actual offense. But more importantly, the judge is connecting the dots. This man is from Louisiana, not Texas, and he gave out his personal information to someone else. That's a red flag for identity theft or fraud. But the judge isn't stopping there. She's ordering a transfer to Bienville Parish. That's Interstate Probation. Folks, if he messes up in Louisiana, Texas can revoke his deferred adjudication. The stakes just got way higher.
As well.
Yeah, that's correct.
All right. So is he going to be staying in Texas, or?
He was arrested in Louisiana. This entire incident on his behalf took place in Louisiana, so he's not even from Texas. He would like the opportunity to go back.
Which parish?
Bienville.
Okay. All right. The court is going to sentence you to 5 years deferred adjudication. There will be a transfer to Bienville Parish. What city is that?
Arcadia, Louisiana.
Okay. All right, transfer to Bienville Parish. I don't know if that's Arcadia, though.
It should be either Shreveport, Arcadia, or Monroe,
All right,
or Ringgold.
because I know it's, well, I know it's not Shreveport.
Could be Ringgold.
Okay, I'll look that up. All right, 5 years deferred adjudication, transfer to Bienville Parish, regular reporting by Zoom or in person, regular UAs, proof of employment or SSI within 45 days of release, no employment as a home health care provider or with minors. Who will you be living with?
My mother.
And are there any minors in the household?
No.
Okay, no residing in households with
Oh, here come the safety restrictions. Judge Boyd just ordered no unsupervised contact with minors, and she specifically mentioned the facts of this case are a little bit different than normal. That is judge speak, for this is serious, and I'm watching you. She's also ordering a psych evaluation, continued mental health treatment, and no contact with the complainant. This isn't just a slap on the wrist. This is a carefully crafted punishment designed to keep him away from certain situations. Quick poll for the audience. Do you think this is fair, or is a judge being overly cautious?
minors. No unsupervised contact with minors. And I understand the facts of this case are a little bit different than normal, but I'm just putting this in here to make sure that things are as they should be. At some point in time, that can be lifted if, you know, he had brothers or sisters or something of that nature.
Thank you, Judge.
There's to be Chapter 62 compliance. There's to be no contact with the complainant. And we'll do a MIC evaluation. That can be done out of custody. Since he already has the SSI, they'll probably have the paperwork for that. And do you have a doctor back in Louisiana?
My main doctor, she moved, but I don't know her name anymore. My mom knows all the information. I don't have any.
All right. And there's to be continued mental health treatment. And is that a private doctor?
No.
Do insurance is public?
Yes, ma'am.
All right. All right, he's to do continued mental health treatment. And we'll have to find out where that is. Probation, there's also a $1,500 fine, and that'll be probated. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. We'll do no possession of firearms as well. All right, back to you.
Thank you, Judge.
You're welcome. Where are we on this identification?
Everything has been resolved from what I can tell. Odyssey is cleared up. The DA's office, there's in their portal, it's all split. They have officially split everything. So the only thing is the CUMV, which we've talked to the state, they've talked to the victims.
Mhm.
We're going to apply for PTD today.
All right.
We just got the offer 10 minutes ago.
Okay, awesome. We need a PTD date, please.
Yes, ma'am. I can do August 13th.
All right, August 13th. Just make sure you follow through on everything, okay?
Yes, Judge.
All right, thank you.
August.
And thank you for dressing appropriately for court.
Oh, I see. Yes, thank you, Judge.
You're welcome. All right, and Mr. Gonzalez, you signed the acknowledgement of discovery?
Yes, ma'am.
All right. The court is calling 2020 CR 6198, State versus Jesse Jason Gonzalez. Can I have parties announced for the record?
David Levinson, on behalf of the defendant, ready.
All right. And are you Jesse Jason Gonzalez?
Yes, ma'am.
All right, the defendant is appearing by Zoom. Mr. Gonzalez, you have a right to appear in person in court. Do you understand?
Yes, ma'am.
Are you requesting to proceed by video?
Yes.
All right, and the court will note that the defendant is confined in another jurisdiction outside of Bexar County. Defense, do you have any objection to your client appearing by Zoom?
No, Your Honor.
State any objections? Court will find that defendant has knowingly and voluntarily consented to appear by Zoom. Mr. Gonzalez, did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney, and did you understand it?
Yes, ma'am, I did.
Are you the same Jesse Jason Gonzalez who was placed on deferred adjudication in 2020 CR 6198 for the offense of unlawful possession of a firearm by a felon on July 8, 2020 for a period of 5 years and extended for a total of 3 years? Is that you?
Correct.
All right, state.
On state supplemental, motion to supplement pending MTR violated condition number 5 in Bexar County, Texas. The defendant, Jesse Jason Gonzalez, did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2026 in violation of condition number 5.
How do you plead to that? True or not true?
True.
He will waive your review.
Any objections to the waivers?
No, Your Honor.
Mr. Gonzalez, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you to 10 years in the prison,
Yes, ma'am.
up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
It is not good, but state would be asking that you grant state's motion, enter an adjudication of guilt, revoke, and sentence to 5 years in the prison. Judge, this is Mr. Gonzalez's third MTR, and what remains consistent throughout is he has a fundamental inability to do one of the most basic things on probation, which is to report. Not only that, obviously, he is in custody in another county, so he cannot comply and comport his behavior to that consistent with what is required by him on probation. And I think because this is his third MTR, he's been given ample opportunity to comply with conditions, that there's not much else he can do. So for that reason, we would be asking for revocation at this time.
Defense?
I would like to present evidence, a witness on his behalf.
Yes. Who would you like to call?
Jesse Gonzalez, his father.
All right, Jesse Gonzalez. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jesse Gonzalez.
All right, defense, you may proceed.
What do you want to tell the judge on your son's behalf? Can you talk to the judge a little bit about him?
He's been a, first of all, he lost his mother when he was 17 years old, and he got into some issues as far as legal issues, and I've been trying my best to calm him down. He eventually now he gave me a granddaughter, and he's expecting his girlfriend is expecting a grandboy, and within days. He has been a real good kid, but you know, it just, yeah. I talk to him every day. I just pray for him to get better.
If the judge allows him to continue on probation, would you said you would talk to him every day?
Yes,
Do that.
absolutely,
Would you help him be able to report?
absolutely.
What's your understanding of his failure to report? But
If I would have known that he had to report, I would have been on his tail. But I didn't know.
how many other children do you have?
I have two older adults,
And
a 43-year-old and a 37.
and how are they doing?
Remember,
What does your older son do?
he owns an air conditioning company.
And your others?
My daughter works for him.
Okay. And is there anything else you'd like to say?
State.
Mr. Gonzalez, my name is Lauren Espinoza. I represent the
Good morning.
Plea. I have a few questions for you to follow up with what you just testified to. Okay.
Yes.
So you just testified that had you known your son was to report, you would have been on him, correct?
Yes, absolutely. Sorry.
Does he reside with you?
He did it sometimes, but not now. He lives in Uvalde.
Approximately what time frame did he reside here?
About a year. Well, probably the time that he had gotten arrested.
For this case?
Yes.
So about 2022? So 2019 to 2020?
It is there probably.
Or can you narrow it to a specific year for me? Is it in 2020?
24.
So he resided with you in 2024. But the instant case we're here for is alleged to have occurred in February.
Oh, no, okay, no, he didn't live with me.
Okay, so he didn't live with you at the time of this comment. Okay, and would it surprise you to learn that it was alleged that police were dispatched for a burglary and then found him with a firearm?
I knew of it, yes.
Okay, do you know him to own firearms?
No, he never owned a firearm that I know of.
Do you know why he would have been in possession of a firearm?
No,
Okay, did he have children in 2020?
no,
No, so it was after this case that he had a child?
yes.
So-
My granddaughter's 2 years old.
Okay, so how can you assure the court that you're going to make sure Mr. Gonzalez complies with probation when he's his own adult with a child?
I will definitely make sure.
But there's no way for you to make sure that 100%.
Of course, but yeah, being as a father, I will.
Any further questions?
No.
Thank you so much for coming in, but this is what I want you to realize, right?
Yes, ma'am.
As a parent, because how old is your son?
25.
All right, he's 25. It really is not your responsibility to make sure he reports. So I want you to know that everything that you've told me has given me insight into your son. It doesn't negatively impact him, what you've told me. All right, thank you so much.
I would just like to make a statement closing on.
Sure.
I'm going to do that now.
Well, let's let the state go first and tell me what they want, and then I'll come back to you.
Judge, we're asking for 5 years in the prison. Mr. Gonzalez is here on his third MTR. He does have a prior probation that he was terminated unsatisfactory in 2024. So because of that.
All right, in defense, what are you requesting?
Your Honor, this is an unusual.
And here we go. This is a part of the video where the real drama unfolds. This is Mr. Gonzalez's third motion to revoke MTR. For those keeping score at home, he was put on probation, violated it, got a second chance, violated it again, and now he's back for the third time. The state is asking for 5 years in prison, and the defense is basically saying he's got a thinking problem. He's not like us. That's a bold strategy. The judge is not impressed, and honestly, neither am I. Can the defense pull a rabbit out of the hat? Or is this the end of the road for Mr. Gonzalez?
The case for me, I know you see these cases every day a million times. So in that light, it's kind of difficult to give you something different or why this case is different than your past rulings, either favorably or unfavorably. All I can say is that I've known this family my whole professional life, 30 years. I've known Mr. Gonzalez, the father. I've known his children, all of his children. I've done cases like divorces and this and that. And they're good people. They own businesses, as you heard, and his brother is a very successful executive. There's been some issues with the family with this child, and you'll see that it's confirmed in the probation report on
Excuse me,
page.
just a second. Do you have the trial court certification facts back yet?
Not yet, sir.
Right.
The recommendation of the probation department confirms kind of what I'm saying, in the sense that they're recommending ISF2, which is
Okay, so let me just tell you something about probation's recommendation. With probation's recommendation, their policy, somebody can be missing for an entire year, and their policy now is they're not going to recommend. All right, they're not going to recommend revocation.
Okay, well, the
So-
reason I'm mentioning is not for that reason. It's for the fact that they're recommending ISF, which is a thinking pattern course.
Mhm.
They're acknowledging that he needs help in thinking. I mean, the simplest thing is to report, for gosh sakes, and it's unfortunate that we're here on that issue in this case, because since his last MTR, he's been pretty clean. He did have one negative about a year and a half ago, but he's been pretty clean relative to a lot of those cases you've seen, I'm sure. And he's completed the parenting class. He has a job, and he tells me that the UPS job that he has requires drug testing because
Why is he in custody?
he's in custody because he was trying to buy a car, and that's one of the problems he's having is transportation, getting here to report, taking a bus. It takes.
So what is his charge?
His charge is a fraudulent check and unauthorized use of a vehicle. So there was some kind of confusion about buying the car. He had the car. The check, I guess, was not, I'm not in that case. I don't know. But apparently there was a check involved, and it may or may not have been fraudulent. It's still pending, the allegation, but it's not a violent crime. It's not something, it's just stupidity, which is exactly what I'm
And
saying.
for the record, I'm not going to consider charges. I just wanted to know why he was there. I wanted to make sure it wasn't a warrant here or something of that nature.
Yeah.
Okay.
Yeah. I just wanted to show you that also he's been in jail over 500 days. In fact, just on this MTR, he got arrested at the end of April. It's been like 75 days he's been in jail in Uvalde. And when I talked to him on the phone over there, it sounds like a zoo over there. It's really not good. If you wanted punishment from my client, he's been punished, believe me. He hasn't been with his family. He's been in that literal zoo of a place. Horrible. He did time of 2.5 months already, 75 days. So he has been punished. He has a job waiting for him. UPS assures him that once he gets out of whatever he's in, that they have a place. They apparently liked his work, were happy he passed the drug testing. So he has a lot of family support. Like I told you, his father's here, his other siblings and uncles are supporting him and his wife, and hopefully they can straighten him out. I know it's his third time, but I'm pointing to this thinking problem. You know, if he was a normal person, we wouldn't be here. Obviously, you know, you can't take him like he's like us. You know, for us, it's ridiculous. I got that, but you know, you have to take him as he is, and he needs help, and that's why we're here asking for it. He's completed the parenting class that was required on his probation. You know, like he said, his wife is due any minute. I would like for him to be there for that. And as a counter offer, if the court doesn't like the idea of following the probation recommendation, and I can see why. But remember, he's done so much time that putting him into TDC, he'll probably get paroled out, you know, and I don't know, I would suggest maybe that you terminate him on SAT. Again, on this case, he's done lots of time. It's not like, you know, oh, he got away with something. He's been on probation almost 6 years. He's been in jail, you know, over a year. I mean, he's paid for the offense of unlawful carrying of a weapon. So just throwing yourself on my mercy to you that I assure you his family is really great and he is making progress. He's got the family, the children, the job, you know, and he told me that one of the problems he's behind in is pay. He hasn't made the fines, the payment due. He said because he had to pay to get off of the interlock, the device that monitored where he was. He had to pay like over $1,000.
All right, that has to be somewhere else because I always waive GPS fees.
Well, maybe.
Oh, you mean the ignition interlock?
Yeah.
No.
You're talking.
No, ma'am, it was the GPS. You put me on GPS back in 2024. And I believe that time, I had to pay like $1,400.
Okay.
So he doesn't make much money. What do you do at UPS?
I'm a package handler.
All right, so let me just explain everybody where we are, because number one, I realize that it's felon in possession of a weapon. We can say what we want to say about that, whether the laws are going to change, who knows? But the law is the law. So when he was first placed on probation out of this court in 2020, I ordered that he reside with his father. Then he had a motion to revoke, a violation of condition number 2. And I altered and amended his condition. I denied the motion. I altered and amended conditions to include a referral to felony drug court. If not accepted, then SATA. Then he came back in 2024 for a violation of condition number 5, which was failure to report. I denied the motion because he was like, I'm having a baby. Okay, great. I don't understand why people start having children when they have the instability of being on probation, but people do what they do. And he didn't report. So I altered and amended his conditions to include parenting classes and GPS for 180 days, partial for employment only. And his case was transferred to Uvalde because he wanted it transferred to Uvalde. Now we're back again. And what are we back for? He's not reporting. There's nothing else I can do with him. And as far as probation recommending ISF, ISF won't take him because he has pending charges out of Uvalde. So I'm going to grant the motion, find him guilty, revoke, and I'll sentence him to 3 years in the prison, given credit for any time served. And counsel, I need you to sign the trial court certification. Mr. Gonzalez, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and electronically sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And Yaya, if he successfully completed any inpatient treatment that was, he should receive credit for that.
Yes, ma'am.
All right, thank you.
And can I get a chance to talk to you, David, or no?
Yes,
Can you put us back in the breakout room?
yes, you can. And this is the wrong trial court certification, but I'll just add what I need to add to it.
Name.
Yes, if you go in the back and they'll do it.
Thank you.
All right, and you say you have Christopher Medellin?
Yes, Judge, I'm on a robbery case. Fernando's on an ag robbery case. We're
Mhm.
both appointed. My office is filing a motion to withdraw. I'm off the wheel now.
Okay,
And I think Mr. Medellin indicated he wanted a different lawyer and he's got a great one.
so
So,
are you going to be on that other case as well, counsel?
I am.
All right. Then you
All right.
withdraw.
thank you, Judge. I appreciate it. We'll get the motion filed.
All right, thank you. All right, Raymond Arredondo. Court is calling 2026 CR 004477 State versus Raymond Arredondo. Can I have parties announced?
Brandon Prater for the state.
Good morning, Judge Alfonso Cabañas for the defendant.
And are you Mr. Arredondo?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Arredondo, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge will be abandoning the enhancement provision, but otherwise.
You're proceeding on both counts?
Just.
Oh, I'm sorry, there's one count.
Yes, my fault, Judge.
No problem, my fault. Any objections to the waiver?
No objection, Your Honor.
All right, Mr. Arredondo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, I did.
All right, you're charged with possession of a controlled substance, penalty group 2, 1 to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He did, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Your Honor.
Mr. Arredondo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor, I did.
According to the plea, punishment is to be assessed at $1,000 fine, probated, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
State defense, is that the plea?
Yes, Judge.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor,
By
I did.
signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years, a TAP evaluation, 100 hours community service restitution, the DOEP course, MRT, and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
Any evidence?
Judge, we offer state exhibit number 1, including all attachments.
No objection to state's warrant and attachments, Your Honor.
All right. All right, State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would fall in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we asked the court to follow the plea recommendation by the state. However, my client does want to address the court
Yes.
regarding the community service hours, Judge.
Yes.
I wanted to know if there was a way I could substitute the community service hours with my job where I work at. I work at Caterpillar.
Mhm.
And since I work a lot of hours, I usually work Monday through Sunday. I never really have time off to like my job just comply. Like I'm a quality inspector. I do a lot of packing.
Let me ask you this. If you drug tested today, what would the results be?
It would be negative. I mean, it would be positive for marijuana.
Okay. So if you're doing heavy lifting and packing, you need to stop using marijuana. Why are you using?
Just stress, sometimes I get stressed out or, people usually at work, just a lot of stress got going on.
Oh, you know what? It's never the job. It's always the people. That's what my mom always tells me. And I find that sometimes to be very true. So do you have any children?
Yes, Your Honor, I do.
What are their ages?
1-year-old and a 7th month.
And do they live with you?
Yes, Your Honor, they do.
All right. And what's up with the tattoos?
Something I did when I went to prison.
Okay. And what's the one above your eye?
That means Islam,
Okay.
Muslim.
Okay. All right. I'm always curious about body artwork. All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular UAs, tests for levels. So you're going to have to stop using marijuana. It's not allowed while you're on probation unless you have a prescription. You understand?
Yes, Your Honor.
And if there are some mental health issues going on, now's the time to have those addressed. Okay.
Yes, Your Honor.
So there'll be a MIC evaluation out of custody, a gang evaluation out of custody, TAP evaluation out of custody. Follow the recommendations for TAP evaluation. If it recommends inpatient treatment, we'll start with outpatient treatment. There's a $1,000 fine. It will be probated. There should be 100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 2 months. Probation, is there anything else? Thank you. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. All right. Anything else you need from the court to be successful?
No, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor. I do.
All right. And I need not remind you, but because of that felony conviction that you previously had, you're not allowed to possess any firearms. Do you understand?
Yes, Your Honor. I do.
All right. If there's something that comes up or you need something addressed, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court. Okay.
Yes, Your Honor.
All right. Good luck to you. Thank you.
Judge.
Yeah, Ethan Gonzalez, Judge.
Ethan Gonzalez.
Ethan.
All right. Today's final plea deadline date. What is going to happen? We're going to be in a jury. What?
Well, Judge, you had given me a reset to get discovery, and I ordered some, I need at least 1 terabyte, so I ordered multiple ones, and I haven't received them. Last weekend, my hard drive crashed. I can't even transfer my data to anything until I get these hard drives that I ordered. And so I'm just gonna asked the court, can I get another extension for the discovery that I need to get?
Is, on his case, does he have a co-defendant or no?
No, Judge, it's just him charged, and he has the murder and the two assaults, but it's all from the same criminal offense.
All right, this jury trial, how long do y'all expect it to last?
5 days.
5 days? All right, Norm, I need a jury trial date and a plea deadline date for a criminal trial division, 5 days. And so
Yes, Your Honor.
if things work out before then, you can have him brought before then.
Yes, Your Honor.
Otherwise, he's gonna be dressed for trial on that day.
I'll be ready.
You're always ready.
Thank you, Judge.
All right, September 1st, that's gonna be your jury trial date and last day to enter a plea bargain agreement.
Can we both approve this, representative?
Yes,
We do have another murder, since we.
Sure. okay.
Judge, on the Medellin one,
Mhm.
I'm getting appointed to the other one. What am I gonna get reset for?
Oh, well, which one are you being appointed on?
The robbery. I got the ag rob, I believe, and I'm gonna get the robbery. So it doesn't make any difference to me. I don't care.
Okay.
And we're gonna end up in a trial either way, so whatever you wanna do, Judge. That's on Medellin.
Okay, all right, just give me a moment.
Yes, Your Honor.
So, Megan,
Yes.
that can remain on September 1st. And if an agreement is not reached, it'll just be a quick turnaround for a trial date on a different day.
Okay, Judge, that works perfectly.
All right, so September 1st is going to be your plea deadline date. And then if an agreement is not reached at that time, it's going to be a quick turnaround for a jury trial.
Yes, Your Honor. Thank
All
you.
right, thank you. All right, you may have your seat. And then Ethan Gonzalez. I'm sorry, that was Ethan Gonzalez.
Yes,
Just
and
one
on
moment.
Medellin, Judge.
All right, Medellin. All right, state on Medellin. Defense is saying this is going to be a jury trial. Do you know which case you all will be proceeding on first?
So probably the robbery, Judge. This is very, it's confirmed, but I would imagine the robbery.
The aggravated robbery?
No, the CTD regular robbery.
All right, so,
Ending in 06.
and you all have the aggravated robbery?
Yes, Your Honor.
All right, he'll be ready on the aggravated robbery, but the other case, he's just being hired on. So that will be the one. How long are you all expecting that trial?
We move fair.
Are you saying the ag robbery or the regular one?
The aggravated robbery.
Same with the, yeah. Probably 3 days.
All right, Norma?
Yes,
I need a 3-day jury trial date for family violence on Medellin. All right,
It might be like a 4-day, Judge. We
Okay.
very likely would do punishment to the jury on that one.
okay.
Judge, I think it's September 8th.
That's not gonna happen because the state has a criminal trial division has a murder case, so it wouldn't be going, put it in August.
August 25th.
All right,
That's the
move it to August 24th. And we'll do jury selection on that day.
Yes, ma'am.
All right, we'll see you back on August 24th for your jury trial and you'll be brought over dressed for trial. All right, thank you.
Next.
All right, who else do you have?
Hector Carreno, Judge.
That's page 3, says at the bottom.
All right, Hector Carino. Oh, that's okay. You can remain in the box. All right, state, were you able to tender an offer?
Yes, Judge, a verbal offer was extended.
All right, Norma,
Yes, ma'am.
I need a recall. Sir, how old are you? All right, Norma, I need a plea deadline date in 3 weeks.
August 3rd.
All right, we'll be back on August 3rd. And at that time, you need to let the court know whether or not you've reached an agreement, okay?
Yes, Your Honor.
All right, thank you. Thank you, counsel.
Thank you, Judge.
Who's your client?
Morning, Your Honor.
Good morning. Who's your client?
Mr. Viamontes, he's present, Judge.
Fernando Villamonte.
All right. All right, court starts at 9 a.m. You understand?
Yes, sir.
If there were to have been another judge sitting on the bench, you would be in custody.
Sorry.
All right, so today's discovery. Do you have all discovery?
I believe I do, Your Honor, but we have a requesting a transfer. Apparently you were the prosecutor in his case, Your Honor, on a deferred.
Oh, I don't even remember.
I know, but
I'm sure I treated you fairly.
he got deferred, Judge, but, but we're back.
There you go. We're back. All right, Norma, do a transfer.
Yes, ma'am.
Thank you,
All right,
Judge.
thank you.
May we be excused. Sorry about that.
He needs a reset date. So Norma's going to give him a reset date, and wherever you're transferred to, that's the date you need to appear. Okay?
Thanks, Your Honor. Appreciate it, Judge.
You're welcome.
Thank you.
All right, thank you. Jeremy Luna. Court is calling 2026 CR 004716. Probation, this is an application.
Yes, sir.
Good morning. Oh, you're on this side of your client.
I wasn't sure, Judge. I just stand in the middle.
Hi, are you Mr. Luna?
Yes, ma'am.
And could you all announce?
Lauren Espinosa for the state.
Greg Gameray for Mr. Luna.
And you're Mr. Luna? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Luna, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Luna, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Your charge is possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Understand?
You need to speak up. Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am. Yes.
Mr. Luna, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine to be probated. State recommends deferred adjudication. There's to be $120 payable to the Bear County Crime Lab for drug testing. Did you understand that as your plea?
Yes, ma'am.
State defense?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 120 hours of community service, restitution, and the DOEP course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Sir.
State any evidence.
Yes, sir. You know, for states exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
We just ask you to follow the plea bargain, Your Honor. And our client is 35 years old. has independent work as a fencer, works with
Mhm.
fence together. He understands what's going on, Judge. Let me just ask you to follow through.
All right, do you have any children? All right, how often have you been using?
Weekly, probably, weekly.
Okay, and if you're tested today, it's gonna be positive, right? Okay, we're gonna do our best to get you some help, okay? All right, the court is gonna sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 2 months, 120 hours of community service restitution. I will deduct 1 hour for every sober support meeting that is completed. I'm going to order 1 sober support meeting per week. Those you can do at any time, anywhere. They're available all over the city, okay? TAP evaluation out of custody, follow recommendations. Referral to felony drug court. $120 restitution to the Bexar County Crime Lab for testing. $1,000 fine probated. No possession of firearms. Do you live by yourself or with someone else? All right. All right, no residing in households with minors. Counsel, that may change once I can see that he's clean and sober and actively in treatment.
Yes, sir.
All right, is there anything else you need from the court to be successful? Probation, is there anything else? All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and here's the thing, when you're riding a bicycle, there are certain rules. You have to obey, you got to do the hand signals. If it's dark, you have to have your lights on. You can't ride a bike. I know people do it, but you're not really supposed to ride bicycles on the sidewalk, okay? And just as a side note, if you're walking, wherever there's a sidewalk provided, you must use it, whether there's cars in the roadway or not, okay?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
Thank you. All right, John Vargas.
Good morning.
Good morning. Why were you late for court?
I wasn't meeting.
We are scheduled for 10:30, Judge.
10:30?
Yes, Judge.
You're right, for the
For the
the
motion to
motion to
suppress,
suppress.
and we're ready.
I was here 15 minutes early this time. Yeah, I was scared. I told my
Okay,
mom,
no, that's good. I'm telling you, nothing gets placed in the system until I speak with people.
Yes, ma'am.
All right, so state on the motion to suppress.
Yes, sir.
Are y'all ready on the motion to suppress?
We have our 2 officers back there. We're ready to go.
All righty, let's bring them up. Court is calling 2026 CR 0022183 State versus John Manuel Vargas. Can I have parties announced for the record?
Krista Giamico for Mr. Vargas.
Okay,
Are we gonna be at the table?
however y'all want to do it.
I prefer that.
All right, sure. All right, in this motion to suppress, what is the issue? Is it the stop? Is it a search warrant? What is it?
Stop, Judge.
Okay,
Judge, state will call Officer Terrazas.
all right. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand there. Cindy, do you have the microphone for her? All right, if you will spell your name for the record, please.
Leste, and my last name is Rrazas.
All right, state, you may proceed.
Thank you, Judge. Good morning, Officer Terrazas. How are you doing today?
Good morning, sir. I'm doing great. How are you?
I'm doing all right. Officer Terrazas, how are you currently employed?
I'm employed with the San Antonio Police Department.
How long have you worked with SAPD?
4 years now.
You like what you do?
Yes, sir.
All right. Walk us through your training. What kind of training have you received in the academy and any kind of TCOL related training you've received afterwards?
All right, just one moment. Hold on.
Officer Terrazas, Did you perform a traffic stop on October 11th, 2025?
Yes, sir.
Did you write a offense report in regards to that traffic stop?
Yes, sir.
Would a copy of your report help refresh your memory?
Yes, sir.
All right. May I approach the witness, Judge?
Yes. And everyone, you may approach without requesting the court's permission.
No, Judge.
Sure.
All right. Officer, I'm showing what's been labeled for identification purposes Exhibit A. You know what this is?
This is my office report for my traffic stop.
Okay, so because it's not in evidence, you're not allowed to read directly from the report. If I ask you a question and you're not sure of the answer, then read your report. Once your memory is refreshed, you can look up, you can answer the question.
Yes, sir.
Good.
Yes, sir.
All right, officer, let's start at the beginning, because that's a good place to start. Where were you when you first observed the defendant's vehicle?
I was parked behind up in the parking lot, almost, watching the hotel.
You said hotel. Why were you watching the hotel?
It's known for narcotics and just traffic back and forth in that area.
Okay. Did you observe the suspect vehicle?
Yes, sir.
What kind of vehicle was it?
A gray Chrysler, I believe. Yes, sir, a gray Chrysler.
All right. So you started watching this gray Chrysler. Did you see the gray Chrysler perform any traffic violations while exiting the hotel?
Yes, sir.
What traffic violations did you observe?
The first one was he did not stop at a exiting the private property. He exited without stopping and he turned into the right for this lane. And he turned into the second lane to the right instead of that first lane closest to private property.
So would that be a violation of Texas Transportation Code 545.256, emerging from an alley, driveway, or building?
Object to leading.
Sustain.
And also, what would the next violation be considered? Improper turn or?
Improper, yes, sir.
Okay.
Again, object to leading, Judge.
Sustain.
All right. While you were tracking the vehicle, did you observe any other violations?
Yes, sir. I observed something obstructing his view on his rearview mirror. I also drove.
I'm sorry, could you repeat what you just said?
He had I believe an air freshener hanging from his rearview mirror.
Okay.
Okay. And is that also a violation of the Transportation Code?
Yes, sir.
Did you perform a traffic stop on the gray Chrysler based on these violations?
Yes, sir.
Okay. What happened when the vehicle pulled over?
Once the vehicle pulled over, both him and his passenger exited the vehicle and closed his doors. They closed their doors.
What were you thinking when the two doors opened up on the vehicle?
I was unsure who was in the vehicle, so for my safety and his safety, I was gonna go up to the driver and detain him due to him exiting the vehicle without any reason.
In your experience, when a door opens immediately after a traffic stop, is that possible officer safety issue?
Objection to leading.
Sustain.
If you'll just give me like 10 seconds after he asks the question.
Yeah, here's the thing. Guess what? Guys, I can disregard things that I've sustained.
Yes, Judge.
So that objection is sustained.
Thank you, Judge.
What happened next after the vehicle doors opened?
Both the driver and the passenger exited, and I approached the driver's side and I told him to just have his hands up where I could see him. And
Did the driver of the vehicle say anything?
no, he didn't.
Okay. Would you recognize the driver of the vehicle if you saw him in court today?
Yes, sir.
Do you see him in court today?
Yes, sir.
Can you point him out to the judge?
Black Nike jacket.
Put the record to select at the witness to identify the defendant. All right. Did any other officers come to assist you during this traffic stop?
Yes, sir. Detective Encina.
Okay. And what would Detective Encina do?
He, as I was attempting to detain our defendant, he helped me detain him, put him in handcuffs.
Okay. And after that, what were you and Detective Encina doing?
We put him in front of our vehicle, and I believe, I'm not too sure what Detective Encina went after that. He did.
Okay. Did you and Detective Encina perform a search of the vehicle?
Yes, sir.
What was found in the vehicle?
Meth, marijuana, and THC things.
Okay. Officer, was your vehicle equipped with a dash camera or a co-bang camera that day?
Yes, sir.
Okay. Was it functioning properly?
Yes, sir.
And just to speed up, I will stipulate to the admission of the video, no objections.
All right. And what exhibit will that be?
That'll be state exhibit number 1, Judge.
And are you offering it into evidence?
Yes, Judge, we
All
are.
right, state's exhibit number 1 is admitted without objection for purposes of this hearing only.
Permission to publish state exhibit 1, Judge?
Granted.
All right, officer. Is this target vehicle right here?
Yes, sir. Object to leaving.
All right, that'll be overruled.
And officer, when is this video taking place? Is it before the violations or after?
This is after, I'm sorry.
And now we've got the cross-examination of the century. Defense attorney Marissa Django is going after this officer's credibility like a pit bull. She just pointed out the officer only mentioned the air freshener as the reason for the stop, not the wide turn or the failure to stop that the officer claims happened before the video started. And here's the kicker. The dash cam doesn't show any of those alleged violations. If the stop was illegal, everything found in that car, the meth, the marijuana, the Xanax, gets thrown out. This is Fourth Amendment 101. Folks, do you think the judge is going to believe the officer or the video?
And officer, what's happening here?
Both the driver and the passenger exit the vehicle. Shut the doors behind them. I'm attempting to detain them at this point.
The defendant complying with your request?
No, sir.
Let me ask you a few more questions. Are you familiar with what a pat down is?
Yes, sir.
When is a pat down performed?
We asked them, or we frisked them for any weapons. And narcotics and anything.
But when is that done?
As soon as they're detained.
Okay. Did you perform a frisk? Or did Detective Encina perform a frisk of the defendant?
Yes, sir.
Was anything found during that frisk?
Yes, sir. A believed pocket knife and Xanax.
At any point, did the defendant say he had a prescription for Xanax?
No, sir.
Is it an offense under the Texas Penal Code to possess Xanax bars without a prescription?
Yes, sir.
Did you ever smell any aromas or odors coming from the vehicle?
Yes, sir. After I approached the vehicle to search, I did some marijuana.
How do you know what marijuana smells like?
My previous experiences in the academy.
Okay. Thank you, Officer. Judge will pass the witness.
Thanks.
Thank you, Judge. Hi, Officer Trustis. My name is Marissa Giavenco. I represent Mr. Vargas. I'm going to ask you a couple questions. If you don't understand my questions or don't know, just let me know, okay?
Yes, ma'am.
Thank you. You said that you've been with San Antonio Police Department. Microphone on? This one or the other one? This one. Is that better? Okay. You've been with San Antonio Police Department for 4 years as of right now, correct?
Correct.
Okay, but this offense was in October of 2025, correct?
Yes, ma'am.
So you had been with the department for about 3 years? Is that fair to say? Okay. And then is that including your time in the academy?
Yes, ma'am.
So how long have you been on the streets at this point? I mean, in October of 2025.
About 2.5 years.
Okay. You said that you were watching that you were in a parking lot, that you were watching a hotel because it's known for narcotics.
Yes, ma'am.
Okay. Your vehicle is equipped with the body cam that we've watched, correct?
Yes, ma'am.
And you're aware that when you turn on that dash cam, it rewinds a certain period of time, correct?
Yes, ma'am.
Okay. But yet, when this camera starts, you're not in a parking lot.
Parked behind a bank in a parking lot. Yes, ma'am.
That's not my question. When this vehicle starts, you're not in a parking lot.
Okay.
Correct?
Yes, ma'am.
Okay. You're at a traffic light. Okay. So you do not see anything on the video of my client pulling out of a parking lot. Correct?
Yes, ma'am.
You do not see him making a wide turn.
No, the dash cam, no, ma'am.
Okay. And you don't see him, what you said, not stopping when exiting a parking lot?
Not on the dash cam, no, ma'am.
Okay. And there's no sound to this video at all?
No.
Okay. When you talk about my client getting out of their car for no reason, you agree they're at a gas station pump, correct?
Yes, ma'am.
When you pull up to a gas station pump, you usually have to get out to pump gas, correct?
Yes, ma'am.
Okay. And we can't tell how long of this video had you had your lights on to pull him over?
No, ma'am.
You did not turn your lights on before you pulled into the gas station?
Yes, they were on. The lights were on.
Okay. But you must not have turned them on much long before this, because otherwise your camera would have started earlier, correct?
Yes, and whenever I turned the lights on, he had multiple times to pull over into a private area to conduct a traffic stop, and he didn't.
Okay. You also stated that both the passenger and the driver get out of the car and do not shut the door behind them, but you would agree that that passenger side door is still open, correct?
Yes, my car's was open.
Okay, so that's contrary or contradictory to the testimony you had earlier.
Yes, ma'am.
Okay. And when you pulled over my client, you actually told him the reason for the stop, correct? And you told him it was because of his obstructed view.
Yes, ma'am.
And in fact, you don't mention the illegal turn
No, ma'am.
to my client. You don't mention the pulling out of the parking lot.
No, ma'am.
Okay. In fact, none of that comes up until when you write your report, which you write your report a little bit later after the stop, correct?
Yes, ma'am.
Okay. But you couldn't have gone back to watch your video because that's not on the video.
No, ma'am, it's not. But I remember what I saw.
Okay. Well, why didn't you tell that to my client then when you told him why he was pulled over? You only talked about his obstructed view.
Because that's what initially I pulled him over for, as a traffic violation on the road.
Okay. So the reason you pulled him over on the road was for the obstructed view.
Referring back to my report, it was all three, but I had told him that it was for the obstructed view.
Okay. And so why wouldn't you tell him all of his traffic violations? Or is that something you remembered later?
Well, him jumping out of the vehicle kind of threw off my attention, so I told him exactly what I was at that time was for the obstructed view.
Okay. And officer, it was actually Detective Infina who started the search. Well, you both started at the same time, but Detective Infina was searching well.
He was searching with me.
Okay, and Defense Exhibit 1, is that Detective Infina? Can you tell?
I can't really tell, but it has to be, yes, ma'am.
Okay. And Defense Exhibit 1 is actually a screenshot of the body worn camera that actually you were wearing. Would you that look accurate?
Yes, ma'am.
Okay. Defense moves to admit Defense Exhibit 1.
No objection.
All right, defense exhibit number 1 is admitted for purposes of this hearing.
And is this the obstructed view that you pulled my client over for?
Yes, ma'am.
And that you would agree is one single air freshener?
From what it looks like, yes, ma'am.
And it's not illegal to have an air freshener in your vehicle, correct?
No.
Okay, and you're saying that one single tree-shaped air freshener is what made you pull my client over?
Yes, ma'am, plus the other two traffic violations.
I have no further questions.
All right, state.
No further questions, Judge. We ask this witness be excused.
Excuse?
Yes, Judge.
All right, thank you. You may step down. State, you may call your next witness.
Judge, I think that we'll rest.
Yeah. And I don't have any witnesses, Judge, just argument.
All right, I'll hear argument.
May I proceed, Judge?
Yes.
Judge?
Excuse me, it's her motion to suppress, so.
I'll reserve for the state. I wanted to make sure she knew she was excused.
All right, you may proceed.
Thank you.
Judge, basically this breaks down to Officer Terrazas observed not one, not two, but 3 different violations. So he observed a violation of Texas Transportation Code 545.256, which I've made a list, and if I may provide that law to the court.
Oh, I'm aware of the law.
Thank you, Judge.
Sure.
Which basically says an operator emerging from an alleyway, driveway, or business or building in a business or residence district shall stop the vehicle before moving on a sidewalk or sidewalk area extending across an alley or driveway, yield the right of way to a pedestrian to avoid collision, and on entering the driveway, yield the right of way to an approaching vehicle. Further, there was a violation of Texas Transportation Code 545.101, turning at an intersection. Slow down. I am so sorry.
All right, if you'll just quote the
As well
code
as,
section, I'm sure the defense is aware of the code section.
of
So
course.
you don't need to read the entirety unless you want to.
No, Judge, for expediency, I will break it down for you.
And there was also a violation of Texas Transportation Code 547.613, which is restriction on windows, which is basically a violation of the air freshener. Judge, the officer has testified, and I have no reason to find her not credible, that she observed these violations, that she began to follow the vehicle, and then she performed a traffic stop based on these violations. Upon her approach, that we can see on the dash camera, the vehicle door was open. She smelled the odor of marijuana coming from the vehicle. That odor of marijuana, which she's trained to identify, gives her probable cause that contraband may be within the vehicle. And under the automobile exception, she is allowed to search that vehicle while having probable cause. Because of that, Judge, there is no violation of 3823 of the Code of Criminal Procedure. There's no legal activity on behalf of the state or its agents. Because of this, there is no reason to suppress any of the evidence that was seized by these officers during this traffic stop. Because of that, Judge, we respect the request that you deny the defense's motion to suppress.
All right, defense?
Yes, Judge. Officer Terrazas tells my client, and I understand this video does not have the sound, but she did testify that she only told my client that he was being pulled over for the obstructed view. You can see in Defense Exhibit 1, one single air freshener is not an obstructed view. That is not sufficient probable cause for the stop. These other two alleged traffic violations, she says, happened prior to the video. If she would have started her lights, her camera, it would have backtracked to show those. There is zero evidence that those actually happened. And the reason why, I mean, she contradicted herself on the stand as well. So I think that that affects her credibility. And I don't think we should be just taking an officer's word that these additional traffic stops or traffic violations happened when she's not giving that information to my client at the scene. She says repeatedly on the scene that the reason for the stop is this obstructed view, and it is one single air freshener. I believe this was a stop that she was targeting my client, and there was zero reason for the stop. And I understand the state is arguing the smell of marijuana. However, she testified that she only smelled marijuana when she went to already search the vehicle. She's not using smell of marijuana as her probable cause to search the vehicle. They had already arrested my client at that point, and they're searching the vehicle incident to arrest. It is not, the smell of marijuana was not the reason for the search. She did not smell it until she already was going to search. And based on this reason for the stop, if they wouldn't have stopped, then they would have never gotten to the smell of the marijuana anyways. I don't believe that these other two traffic violations occurred. I don't think we should be taking her word for it. And the one single air freshener is significantly not enough probable cause for a traffic stop. And we'd ask that you grant the motion.
All right. So I'm going to review the video, the exhibit that was admitted into evidence, and then I will have my ruling for both parties this afternoon.
Okay, Judge. And are you requesting our presence this afternoon?
Yes.
I have a doctor's appointment at 2:00.
Okay. All right, go to your appointment.
Okay.
All right. Thank
Can
you.
we come back tomorrow morning, or
Sure.
just in case if you wanted us here for the ruling?
Yes, I do.
Okay. Tomorrow morning at 9 o'clock?
Yes. Who's here on Luis Galvan? All right, if you'll come forward, sir. And then I'll take that up. Teresa. See, Deputy Laura, they never sent our panel up, which is good.
Hours, so that means so that you can write this over. All right, sir.
All right, the court is calling 2026 CR 003019 State versus Luis Galvan. Can I have parties announced?
Lawrence Vance for the state.
Alexander Kress for the defense.
And are you Luis Galvan? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Galvan, did you review the application for community supervision with your attorney? Did you understand it? I'm going to need you to speak up.
Okay.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Okay, off the record for a moment. Okay. All right, Mr. Galvin, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, court doesn't have to follow the plea. If I give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state was calling the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was, Your Honor.
Mr. Galvin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Okay. All right, just one moment. All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
And state and defense, is that the plea?
Yes, Judge.
It is, Your Honor.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State on State's Exhibit 1 and all attachments.
Any objections?
No, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Understood, Judge.
All right, court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. The court will sentence you to 7 days in the Bexar County Jail under 1244. Give you credit for any time served. The court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You've obviously been through a lot in your life, right? If you continue on the path that you're on, where you're using drugs, one or two things are going to happen. One, you're going to end up going to prison. You're going to end up going to jail. And who knows? The person you may be before will probably not be the prosecutor that you're dealing with now. You may not have this same attorney. You may have a different judge, and they may not consider your past and what to sentence you to. You understand? So if you have a drug problem, there are plenty of places where you can go to get help. You understand? All right. Do you know of a place you can go if you need the help? All right. Good luck to you. Thank you.
Thank you, Your Honor.
You're welcome. It's Shanae Williams.
She left. She was here, but she left.
No, she came late too. All right, the court is calling 2026 CR 005688. State versus Shanae Williams. Can I have parties announced?
Teresa Max Vasquez for the defense. Lauren Espinosa for the state.
All right, this hearing was scheduled at 9 a.m. The defendant did not appear at 9 a.m. The defendant was late. This case was recalled for this afternoon at 1:30. It's now 1:43 p.m. The defendant is not present. Defense, any contact with her?
Yes, Judge, I just got a response from her. She said that she left, that she appeared and then left due to a family issue, a child issue. So I just asked her if she was coming back, that we did have this issue on Thursday. She appeared inappropriately dressed on Thursday, left, and then did not come back And so we're here. And I have not received another response from her, so I don't know.
State,
Requesting a bond forfeiture, Judge.
all right, that will be granted. Your client will be remanded without bond. And it's also on cause number 2026 CR 007149D. Thank you.
May I have a question, Your Honor?
Yes.
Confirm with the state, we want to set it for a dispositive
Who is your client?
Ruben Sanchez. But I wasn't sure if I had to get in line to talk to you or talk to you first and get in line.
I don't think anyone else has signed in. Ruben Sanchez,
You got page 5.
come forward. Hello, how's it going?
I've been good, Judge. Yourself?
Great, I cannot complain. All right, so here's the thing. Do you know what time court starts?
Yes. Yes, Your Honor.
9 a.m. Now, if you were before another judge, that judge would probably issue a warrant for your arrest, and then we would know where you are because the jail would bring you over. Do you understand? Do not be late for court again, okay? All right, so counsel.
I wanted to approach the court. I've confirmed with the state to see if the court would let us set for a dispositive motion to suppress.
Okay.
In the case we close out one way or the other on or before that date.
All right, Norma, state how many witnesses on this motion to suppress?
Judge, I think we'll need about, be a 1 witness.
So Norma, 1 witness. Can you put it next week, maybe? Are you available next week?
On Monday, I'm starting a special setting. We actually are going to go. I kid you not. But if you want to set it next week, we can. But I mean, I'm like 99% confident.
Which
We're
court?
Judge Pena, 290th.
All right. We shall see. Norma, let's put this for the 20th. And if it goes, of course, we'll know.
Perfect. I just want a full disclosure.
No, I appreciate that.
Thank you, Judge.
All right. Have a good one.
You as well, Judge. Don't leave it. Make sure we get 3 separate. Grab a seat. Go. Just don't leave it.
All right. Anyone else ready?
Judge, we're ready.
Yes.
Thank you, Your Honor.
You're welcome.
That's 7-1. 7-1.
Yes.
Yeah.
Go. Sorry, Steve.
Hi.
Hi, Judge. How you doing?
What cause number is this?
Your Honor, it's 2023 CR 8486.
Would you like him before the bench, Judge?
Is he on the docket today or no?
I think Chris had her put on the docket. Annabelle, Bella.
Let me see. Oh, we're supposed to be having a contested hearing on the 30th.
But we have it worked out.
We do have it worked out. Your Honor.
Told us to come back if we get it worked out.
Okay, awesome. I don't know if this is on the docket.
I think it might be last minute.
Norma, do you have Annabelle Marie Vela on the docket?
No, ma'am.
I'm sorry, Judge.
All right, so you all have to talk to probation and talk with the state to see if they have documentation for me.
Yes, Your Honor, we did prepare that ahead of time if the court would like to review. It's just an agreement to withdraw and then alter and amend if the court allows.
All right, let me see the motion to revoke.
Judge, would you like to before the bench or just leave it?
Yes.
You may remember, you may not remember, we had a hearing for a bond setting Friday.
Yes.
We're fast, Judge. We're back today.
Oh, yeah, you are. Hello. Hi. You're looking better this time around.
Yeah, every time I come in the other outfit, it's never good. So I always try.
Yeah.
Do you have that case in the
It is 2023 CR.
To DC.
8486.
DC 2023.
And whenever I go to summary, it's always so hard to find.
Judge, I could talk while you're looking, if you could multitask.
Oh, of course I can multitask. I'm a woman.
It was.
Can you believe he would ask such a question?
There was I think one allegation of a new number one, which was an assault.
Mm-hmm.
And
it was with Mr. Steen.
Yes, you're exactly right.
Your Honor, you asked for the motion to revoke?
Yes. Cindy, because you know what? I grew up in the era. You remember the commercial Anjali?
Yes.
You know, I can bring home the bacon fried up in the pan. All right. And so the complainant was.
They contacted the complainant.
Yes, Your Honor, we did contact the complainant. There is an emergency protective order in place. We would like that to remain in place and there to be no contact for the duration of that order. And then he's fine with it being changed to no harmful or injurious contact order after that. He just wants some time for heads to cool and then he did also state that anger management would be beneficial.
All right, so here's my question. The assault case, is that a misdemeanor?
That is a misdemeanor, Your Honor.
All right. Probation, are you ready?
Yes, Ron.
So on this case, then we'll go on the record. Court is calling 2023 CR 8486 State versus Annabelle Marie Vela. Can I have parties announced?
Ashley Jones for the state.
Paul Acevedo for the defense.
And are you Miss Vela?
Yes.
All right, so off the record, the state is requesting that the motion be withdrawn. And state, you said you've spoken to the complainant?
We have, Your Honor.
All right, and you all have agreed to alternate meeting conditions to include anger management and no contact with the complainant?
Yes, Your Honor. It's also my understanding that he would like that no contact order modified in October to a no harmful injurious.
That is correct, Your Honor, upon the expiration of the emergency protective order.
Well, before I lift any no contact orders, I'll need to speak with the complainant.
Understood.
Okay. So the court will sign the motion to withdraw, alternate amend conditions to include the following. There's to be no contact. Is there anything else you need from the
Judge? There's one more thing, and I don't know if it's outside of the bounds of the court right now.
Mhm.
She is currently pregnant.
Mhm.
I don't know how to say it, but her body is changing physically because of the pregnancy, and she does not have any clothing. They were cohabitating. She hasn't had any contact with him, and she hasn't been able to go retrieve any of her personal items.
All right, so does she need to go get
She
her
needs
clothing,
to
or
go
she
get-
needs me to have somebody provide her with clothing?
She needs to get her stuff.
My kids' birth certificates and social, so I also need them around at that house. And my son's starting first grade coming up in August, and my daughter needs daycare, but I need all.
So
of
do you
them.
have anyone else who can go over there and
We
pick up?
do, Your Honor. A personal friend of hers has made an attempt to go get the stuff from him prior. He seems like he's willing to turn over the stuff. However, we just wanted to make it clear that that stuff needs to be retrieved.
All right, you can have it retrieved through your friend. If there's an issue with it being done through the friend, you'll need to let me know a date and time, and you can go over with a police escort.
Understood.
Probation. So she is allowed to have her friend go to the complainant's location to retrieve items. If there is an issue with her friend or the complainant not wanting the friend there, but wanting the complainant there, then that will have to be done with the police escort, and they'll need to provide you date and time. All right, thank you.
Thank you, Judge.
You're welcome.
Appreciate you.
Excuse me, counsel.
Yes, Judge.
You can give that to probation. Oh, and also this. Thank you.
Thank you, Judge.
Cynthia Dino. Hi, if you can come down, please. Hello. Hi. So your attorney suffered an injury. So she is not available today, but she will, I can recall it for Tuesday. I'm sorry, not Tuesday, Thursday.
Thursday this week.
Yes. Okay. Are you doing okay? What's going on?
Still having a hard time there. Like, I got attacked on the night of the 8th of June, and my phone. A girl came in, punched me in the face 6 times, and broke my nose.
Okay.
I'm not having the time there. It's been very frustrating. And my dog left. I get out of my home on 22nd. She's been in there, well, she was in my apartment for 2 days. They wanted me to come sign a paper to have her utilized, and I just, I'm having a hard time.
Okay, well, with regards to any injuries at the jail or any altercations, just let the deputies know and they'll take it up to the proper channel.
Well, we did do that. I went to the hospital and the officer said she allowed the girl to jump on my bed and he punched me 3 times in the face. She allowed it. And then that's when the search came in. And then I got hit 3 more times in the face. And that was Officer 2059 in the ends. So she was aware of the situation. We have 360 cameras all the way around and voice. And it's very known that the girl came on top of the bunk and I could have kicked her and probably killed her had I did that. But I don't go around assaulting people. So I did not do anything. And I was on my top bunk when it happened.
All right, so I'll make sure that the deputies are aware and just let your attorney know, all right?
Oh, well, and that's another thing. It's a hard time contacting her because she never responds to me.
Well, what I can tell you, she's going to be here on Thursday. If she's not here, we'll have managed assigned counsel come down, okay?
Understood. I appreciate that.
All right, you're welcome. All right, we're going to go on the record in 2023 CR 4371B, State versus Marco Antonio Marino Vasquez. We have an interpreter here. If you can raise your right hand.
Give your.
Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, and then for the state
Megan Galloway from state.
and for the defense.
David A. Garcia, attorney for Marco Moreno Vasquez.
All right, and we have an interpreter in training. If you'll state your name for the record.
All
right, thank you. All right, both parties have agreed to start jury selection tomorrow morning. Is that correct?
That's correct.
That's correct, Judge.
And then that'll give you a chance to maybe get different clothing if you want to. The jurors will be up here. I've asked them to be up here first thing in the morning. They probably won't arrive till 10. So I'm going to ask that everyone be here no later than 10 a.m.
Yes, correct.
All right. And then the court has received an acknowledgement of discovery. Counsel, have you received all discovery and reviewed it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. And then defense, it's the court's understanding that you have motions.
We do, Judge. There's about 9 from defense and several from the state.
Okay.
And the prosecutor and I went through them this morning so that we can sort of make it easier and just put on the record what we're all agreed on.
Okay.
So motion for discovery, we're agreed and everything's been turned over. There's an order in the back.
All right, the court then is signing the order on the motion for discovery, and for the record, the court will note that the defense has stated they've received all that's been requested and the motion for discovery.
Judge, the next one's motion for discovery of punishment evidence. The state agrees to that and they've previously emailed me one. They're going to be handing me one today, which I'm in receipt of.
All right. For the record, the court will note that defense has stated that he has received discovery for any punishment evidence. And the court is signing the motion that it is agreed to.
The next motion, Judge, is motion to require state to reveal agreements. There is a co-defendant who previously pled. The state and I went over it. They are agreeing to this motion and telling me that there are no agreements regarding any witnesses in this case against Marco Moreno.
All right. My pen just died. All right. For the record, the court will note that the state has informed defense counsel that there are no agreements that have been reached between the co-defendant and the state, and the court is signing the order that if something changes with that, state let defense know.
The only thing with that is, so just so the record is clear, there is no agreement that the co-defendant had previously entered into a plea before the court. And so I am going to tender a copy of the admonishment and stipulation to counsel.
So received. Judge, the next motion is the motion for witness list. which is agreed to, and the state has previously provided me one, but they're going to provide me another one this morning
All right.
or this
Then-
afternoon.
Thank you. And the court will sign the agreed motion for the state to tender a witness list.
I've received that, Judge. The next one is a motion for discovery of exculpatory and mitigating evidence, basically 404B, which they're agreed to, and it's a continuous duty that they understand.
All right, the court will sign the order and note for the record that the state is in agreement and the state is in compliance with any exculpatory and mitigating evidence.
The next one is motion to suppress, Judge. Statements, which we're going to run with the trial because there is a statement to the police that my client gave when he was arrested, which they've transcribed. So that's agreed to, and we're running the motion to suppress any statements with the trial.
All right, so the statement is in Spanish?
Yes, Judge, and it has been transcribed by the certified translators here on the floor at a trial of the notice in advance of 45 days prior to the trial. And so the state plans to approach the court prior to calling the witness that we would proffer the exhibit through to have a hearing outside the presence of the jury on 3822, and I can also provide you the copy of the transcription.
Yes, if I could have a copy of the transcription. Because of course, I don't know what's in the transcription, and I don't know if there are certain things that the state has agreed would not be placed before the jury. So we'll just.
And I'll go through that tonight and we'll discuss it tomorrow morning before they proffer it.
All right, so let you keep that.
Okay.
Because it tends to get.
All right. The next one is a 404B notice, defendant's request for notice of state's intention to use evidence of extraneous offense at trial, and they will approach, it's agreed to, but they will approach if they intend to use anything in their case in chief.
Yes, Judge, so the notice that I filed encompassed any evidence that I would intend to use in case in chief and in punishment regarding impeaching the defendant or any prior convictions, but I am in agreement to approaching the court before getting into any of that.
Okay.
Thank you. Next is the motion to suppress, Judge. They're not intending to induce anything other than statement to my knowledge, but that could change. And so if it does, they're agreeing to come before you before any evidence is proffered to the jury.
I'll let you hold on to that. Yes.
Okay. And then last, Judge, is a motion in limine. And so that's regarding any prior convictions. Included in that is the fact that there's an immigration hold against him. There's also an issue regarding how the police got to him. It's my understanding that at the crime scene where the murder took place, they were able to look at video and get the license plate of a vehicle. They tracked that vehicle down to the registered owner, who's not my client, and they spoke to him. And in that, he was telling the police something to the effect that he reported the car stolen, that he had contracted with my client to purchase it, to sell it to my client. But at some point, funds were not remitted to this alleged owner. And so he reported it stolen. I've talked to the state about it. I believe they're in agreement that they're not going to introduce that.
Yeah, Judge, so I believe the issue regarding payment possibly could be broached in punishment, but the intention of calling the witness is just to get the agreement and the circumstances and how the defendant ended up with the motor vehicle and guilt.
So we discussed that if they do bring that witness, he needs to be prepared to talk about he sold the car to my client and not go any further regarding an alleged
theft. Okay. Well, I will tell you, both parties just need to approach and state, just let your witness know.
Yes, Judge.
And I believe that covers all of our motions, Judge.
All right. And state you have motions?
A motion and for me, I'll get it printed for the court, but it's just regarding any wrongs, bad acts, or crimes of the named complainant and the indictment, Danielle Fernandez Valadares, or any other witness that is called by the state, as well as any information turned over to defense under 3914 regarding prior disciplinary actions of any officers their probation. And it's just that he agrees to approach before he.
So what I'm asking is after they finish with their directive, their witness, that they proffer me the NCIC, TCIC, so that I can look at any convictions or bad acts, and then we'll approach and discuss what I can get into.
Yes. All right, just approach. And if someone feels like, oh, should I approach on this? Just approach. All right. Anything else?
I think that covers everything.
All right. And has your client done an election of punishment?
He has not, Judge. I was going to talk to him about it, and we'll do that tomorrow.
Well, if we could get it done today.
Okay.
So we'll do the sign in the election of punishment. The court has not made a decision on your case, but everyone who's up for trial, they have to make a decision on if they were found guilty, if they would go to me for punishment or go to the jury for punishment.
So we'll discuss that. You can make a decision. Okay. The one other thing, Judge, is since we're going to have one or two interpreters here, because I understand some of the witnesses speak only Spanish, that the state's bringing in voir dire, when we speak to the jurors, I'm sure a huge percentage speak Spanish. So do we want to instruct them that they're not to interpret it themselves?
I always do that.
And let the interpreter make the interpretation?
Yes.
Okay. I think that, because I was going to touch on that, but I didn't want to step on your toe.
Oh, no. I always tell the jurors that whether they speak a language or not, that the interpreter is the official interpreter. And if they think the interpretation is correct, great. If they think it's incorrect, doesn't matter. They go with what the interpreter is stating.
Perfect.
Okay, sure.
All right. Thank you, Judge.
Great, thank you.
We'll make that decision and then I'll see you in the morning.
All right, thank you.
Thank you.
You're welcome. Oh, Donata. Now see, Deputy Laura, they haven't done very well with me by Spanish. That's on them. It's the teacher, not the student. But I do know thank you is not Spanish.
She's not a very good student.
They won't even give me an assignment. Where's my homework? What is happening with McCormick?
Oh, yeah.
Yes.
Okay. I received an offer from the state.
Okay. Miss McCormick, come down.
Hi.
Hi, how are you doing?
I'm okay.
All right, so
Received an offer from the state, Your Honor, and we're still negotiating. I wanted to do a counter offer. State, he says that he's going to look at the videos that I mentioned, and then in order to perceive it, reconsider what he offered. My client, they found some lumps in her throat and just went for a biopsy. So she's waiting for the doctor to, she's going to see the doctor pretty soon.
They're going to send me to a specialist.
all right, and when is the specialist?
The ear, nose, and throat doctor.
No,
but-
I mean when?
Oh, I'm not sure. They just call us out.
Okay.
And so I'm just asking for, if not, we set it for trial? Is that what
I'll set it for a plea deadline date, and what I will do is, because you're saying she's seeing a specialist.
Yes, Your Honor.
I'm going to set it for a plea deadline date. And if you find out before then that you all haven't reached an agreement, we can actually do the plea by Zoom.
Yes, Your Honor.
All right. So Norma, recall this in 3 weeks for a plea deadline date.
Thank you.
You're welcome.
Could it be after August 3rd, Your Honor?
Sure. Norma, can you put it after August 3rd?
Because I have a trial on August 3rd.
Sure, no problem.
Thank you so much, Judge. I appreciate it.
You're welcome.
Thank you, Your Honor.
All right. Yes, August 10th.
That's good. That's cool.
And Norma, if they reach an agreement, it'll be by Zoom. All right, Mr. Satanawa. Hello. So here's the thing. I can't give resets when you're just saying, hey, this is what my attorney told me. It has to be emailed in. So Ms. Ferguson just got the email, so I'll give you your reset, okay? All right, Norma, on this case, are you employed?
Yes,
And what's your work schedule?
I work from 9 to 6,
I mean, what day of the week? I know you told me before, but the day of the week, I don't recall.
Monday through Friday.
Monday through Friday.
On Wednesdays, I'm on call Wednesday, so I go in at 4:30. So the morning is more open.
All right, Norma, can you recall this for in 30 days and don't put it on do you want it on a Wednesday or no?
Yes.
All right. And you'll put it on a Wednesday.
The 19th.
All right. Once you have the reset form, you'll be excused.
Yes.
Court is calling 2026 CR 007-987 State versus Jade Guthel. Could I have the parties announced?
Lauren Espinosa for the state. Lauren Lefton for Miss Guthiel.
All right. And the last person who was here informed me that the identities have been.
Yes, thank you.
Oh,
It's without that phone call, I think we would still have.
It's almost like you guys should pay me money for doing that. I don't know.
Very helpful.
Yeah, I'm glad it's taken care of because when it isn't, oh my gosh, that just messes up everything. All right. And you're Jade Guthel?
Yes, ma'am.
How do you pronounce your last name?
Guthiel.
Guthiel. All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications? All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
Should I give this to? State, are you proceeding on the indictment as presented?
Yes.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Has anyone threatened you, coerced you, placed you in fear to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 106 days in the Bexar County Jail. Under 1244, there's a $600 fine and there are no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense and state, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State, any evidence?
Yes, Your Honor. State offer states exhibit 1 in all attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we have obviously, Ms. Ms. Guthiel's due date is on the 20th of this month, so we would ask that she not be forced to deliver in custody and you follow the agreement.
All right, is this intended to be a judgment satisfied?
It is, Your Honor.
All right, the court will sentence you to 106 days in the Bear County Jail under 1244. There's a $600 fine, time and money run concurrent. Court will give you credit for any time served, and the court will show that the judgment is satisfied. They'll probably release you at midnight.
She does have pending misdemeanors, but she's set for court on Monday with another attorney, but Wednesday, but I've informed him of the plea agreement, which involves those cases as well.
Okay. All right. Did you review trial court certification of defendants' rights to appeal with your attorney? And did you understand it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Here's the thing. Number one, you look much better than when I first saw you. So that means that one, you're receiving prenatal care, right? Two, your eyes are wide. There's life behind the eyes. Do not do this thing where you get out of jail and then you go back right to what you were doing before, because it's not going to go well. If you go back to what you were doing before, what's going to end up happening is police going to get involved. Child Protective Services is going to get involved. And you know what Child Protective Services will do? When you go to the hospital, deliver your baby, they will be right there to take your child. Okay?
Yes, ma'am.
So there are plenty of places for women. There are plenty of places for pregnant women if you don't have a place to stay. Do you have a place to stay?
Not to speak for you, but I've spoken with her mother, and her mother is preparing to assist her when the baby is born.
And make sure you listen to your mom, because she's stepping up the plate to probably be your mom, the baby's mom, and helping you with everything. Trust me, if you've survived your childhood, your mom knows what she's talking about. Okay? All right. Good luck to you. And if you need anything, I'll be here.
Thank you.
You're welcome. Thank you.
Just have a seat. Do you have any questions?
All right. Who is here on Donald Belzon? Bye. Have fun.
Yeah, I'll see you soon.
All right. And I'll send you a text message about that.
I would love that. Yes.
All right. The court is calling 2026 CR 006011 State versus Donald Belzon. Can I have parties announced?
Knows for the state.
Glenn Payne for the defense.
And are you Mr. Belzon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Belzon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
No, judging, leave it abandon the punishment.
Any objection?
No objection, Your Honor.
Right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. At the state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
We've spoke about this case, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is waiving the enhancement allegation. They're asking that your punishment be assessed at 8 months in the state jail facility. There's a $600 fine and no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State,
Yes, ma'am.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, state offer states exhibit 1 and all attached.
I reviewed it with my client, no objection.
All right, state, you may be excused. Mr. Belzon, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client's been telling me that he has attended NA and AA meetings and also
Healthy relationships and anger and it's a long story. You know, there's too much time not enough time to explain it, but I'm tired of being out of jail, and I've been on my own since I was 18, so I just barely started to stay with my sister. Coincidentally, she started doing the same thing I was doing, so it was kind of a fallback. But she's clean now, and I got work lined up, so I kind of figured I had to do some time anyways, because I was back out there doing what I was doing, same thing, you know. So I just gotta bite the bullet and do what I gotta do. Yeah. But thank you for, you know what I'm saying? Like I told you last time, thank you for been hearing that you've been blessing a lot of people, so you got respect for me.
Well, thank you very much. And I hope you're going to change things, because this is just end up being a cycle, okay?
Yes, ma'am.
All right, the court is going to sentence you to 8 months in the state jail facility, give you credit for any time served. There's a $600 fine, time and money run concurrent. The court will suggest the therapeutic community. That's to help you with any rehabilitation, but I don't have the jurisdiction to order them to place you in the program. You'll have to ask for it as well. And it is shown on the judgment that I'm requesting the therapeutic community for you. And there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own any weapons or firearms. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. When you're released from custody, the first thing you need to do is find an AA or NA meeting.
But I still gotta deal with parole, so I'm probably.
No. But when you do parole, because I used to do parole hearings as well.
Oh, yeah.
Yes. When you do parole, what's going to end up happening is they will give you conditions, but they'll also give you resources to help you. So take advantage of that. That's sort of like a safety net, okay?
I didn't do this that time, yes, ma'am. Yeah,
All right.
she lives right by the parole office, so yeah, I just was slacking.
Oh, no, I know it's hard because you have so much temptation, but do right, okay?
Okay, thank you.
You're welcome. Have a good one, okay? You're welcome. Court is calling 2026 CR 004449, State versus Luis Mendez. Can I have parties announced?
Brandon Griffith, the state.
Impagaegos Carrillo for Mr. Mendez.
And are you Mr. Mendez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is the court will find that the state is in compliance with discovery. Mr. Mendez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Mendez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, you're charged with terroristic threat, impersonating public servant, or placing the public in fear of serious bodily injury. As a third-degree felony, the range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was competent.
Mr. Menendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 2 years in the prison. Did you understand that to be your plea?
Yes, Your Honor.
State defense is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence?
Judge, you have to say exhibit number 1, including all of its attachments.
No objection, Your Honor.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client on that night had too much alcohol and he's been remarkable ever since. He's been here ever since. And he just wants to pay his debt and move on with his life. He regrets whatever words he may have said that night.
Okay. All right. Anything you'd like to say?
I'd just like to apologize to anybody that felt threatened or were afraid. I apologize to the court. This could have easily been avoided, and your time could have been used better, better ways. So to apologize, I'm very regretful for what happened.
All right, then the court will follow your agreement. And does he have prior criminal history?
Nothing I'm aware of, Judge. I can answer your question.
Sure. All right. All right. So as previously stated, the court has found you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. There's to be no contact with the, what is the name of this bar?
Ringer Pub.
Yes, with the Ringer Pub located at 2826 Thousand Oaks Drive in San Antonio, Texas. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Right, because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney.
And Your Honor, he has 191 days.
Right, you'll receive credit for that.
Right.
Hopefully the 2 for 1.
Well, not the 2 for 1, the 2 for 1, 3 for 1, that's the sheriff. All right.
I already explained that to
Up the
him.
guy now.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Take care of yourself. Okay, Your Honor,
Yes.
on Mr. Rodriguez, on Kevin Rodriguez. there's a new case and some other, and then the probation case, of course. Since which I have to investigate in
Yes.
order for me to make a good recommendation to Mr. Rodriguez. So I'm asking for since I just got appointed.
Oh, yes.
Okay.
All right, Mr. Rodriguez, if you'll come down. All right, so you don't have any objection to this attorney being appointed to represent you? Okay, so what we're gonna do is we're gonna reset it so she can have time to do her proper investigation, okay? All right, 30 days?
Yes, Your Honor.
All right, so we'll recall it in 30 days, but if she wants to come back before then, she'll let us know.
Okay.
All right, Norm, if I can have a reset for 30 days? So we'll be back on August 13th. Is that good for you?
Yes, August 13th.
All right, we'll see you then.
Thank you, Your Honor.
Welcome.
Thank you for signing me someone so fast,
Oh, you're
because
welcome.
normally it takes a minute.
Oh, no, you're welcome.
Thank you. I'll set up a visit for. Okay.
All right,